Okay. So I'm Tim Collins, and with the law firm Collins, Stopkins and Miller, and we represent tenants in the city. We have for the last 20 or 30 years, and it seems as though tenant representation tends to run in cycles, depending upon what's happening with the economy, how valuable housing is, how aggressive landlords want to be to get tenants out, and changes in the law. And oftentimes changes in the laws have been detrimental, and certainly the deregulation process that started back in the 1990s has left a couple of 100,000 units, have seen a couple of 100,000 units coming out of rent stabilization. So there are fewer and fewer opportunities to find rent stabilized housing. There are a couple of developments, one which is really quite monumental, starting in 2009, with a recognition that buildings which receive the J51 tax benefits, usually for upgrades and rehabs and so on, would be now recognized as rent stabilized. And I want to get to that in a minute. The other development, which is sort of significant, and it still has not yet been resolved by the Court of Appeals, has to do with a case known as the Altman case, which basically says that for a certain period of time, up to 2011, and now there have been some code changes which support this, if the outgoing tenant paid less than the vacancy deregulation threshold, so the outgoing tenant's rent was within the stabilized range, then the unit would remain stabilized for the incoming tenant, even if the owner was able to get increases after the tenant left. Again, that has been supported by the appellate division in this county, but it still has to be reviewed by the Court of Appeals, and we're uncertain as to what the ultimate outcome is going to be. So that's one way a lot of tenants have been able to assert rent stabilization rights. But let's step back a little bit. How many of you believe that you are living in a rent stabilized apartment? Okay. How do you know it's rent stabilized?
My niece says so.
Lease. Any other? Okay. Your lease could say this apartment is not rent stabilized, and it may still be stabilized. Your lease can say this apartment is rent stabilized, and it may not be rent stabilized. Okay?
That's bad news.
You cannot contract with an owner to establish rent stabilization rights. Rent stabilization is a matter of law. You can even contract with the owner to recognize your unit as stabilized. You can go to the court, the Supreme Court in this case, and get a judgment basically declaring that this is the case, and it may still not be rent stabilized. Because rent stabilization is a function of law. It's not what you agree to. It's in some instances, and very rare, it's not even what an individual court may say it is. It's what the law provides. Okay? So the basic rules of thumb in asking the question, are you rent stabilized? And again, we distinguish this from rent control. You all know rent control tenants. They tend to be real old. Excuse me if I got some younger rent control tenants here. But the average age of a rent control tenant is well into the 70s. They had to have been occupying the apartment since before 1971, mid-1971, and either they or their lawful successor. And so now there are fewer than 40,000 rent-controlled apartments in the city, and they're by and large occupied by an elderly population.
Before 1971?
71. Rent stabilization covers over about 1 million units. Okay? And there are a lot of ways into the rent stabilization system and a lot of ways out of the rent stabilization system. So the primary indicator of whether you're rent stabilized is a minimum number of units. Do you all know how many units you have to be rent stabilized?
12.
6.
6. Here, 6. Who'll give me 6? Okay. 6. 6 or more. Now, what if you are in a 4-unit building and the landlord illegally subdivides a couple of units? So now you're in a 6-unit building. The certificate of occupancy says 4, but there's 6 families living there. Are you rent stabilized?
No.
Yes, you are rent stabilized. Illegal acts of the landlord do not immunize them from the reach of the law. If there are 6 dwelling units, whether they're legal or illegal, whether it's in a, even in an illegally occupied building that should have been commercial or something, you can assert certain rights. And there are also loft issues that come into play, which I'm not going to go into here. But basically, if there are 6 units and they if the 6 units were made after 1974. Why is 1974 important? Because generally, buildings constructed after 1974 are not subject to rent regulation, except if they got a 421A tax abatement, which is they were basically subsidized by city tax credits, in which case they do come under a form of stabilization. But 421A buildings are new and tend to be very pricey because they can establish initial rents at a high amount. And if you're 421A, the luxury decontrol provisions, which I'm going to talk about in a minute, don't apply. The other is J51. J51 is not for new construction, but mainly for upgrades and rehabs and so on. And the DHCR back in 1997 issued a bulletin basically saying, or an opinion saying that if you get J51, you're not necessarily rent stabilized. And some very enterprising lawyers back in the mid-2000s looked at the language and said, hey, wait a minute. The law basically says, in effect, that if you get this benefit, your tenant should be stabilized. And the DHCR's reading is just not reasonable. And so they went through the court system up to the Court of Appeals, and that's the famous Roberts case, which took thousands of units in Stuyvesant Town, Vancouver Village, which were not regulated or not recognized as regulated at the time, and in a class action suit secured their protected status, their stabilized status, and resulted in a very large overcharge awarded to the tenants there. If the building was receiving J51, it is rent stabilized. Now, so let me go back a little bit. Building was built before 1974, it has 6 units or more, or even if they're illegally constructed, it's rent stabilized. If the building is built after 74 and gets a 421A, which is a new construction abatement, it's stabilized. If the building had units that were coming out because of luxury deregulation, for a time it was $2,000 or more. If the building became vacant, it became deregulated, which was the case in Stuyvesant Town, which had been built long before 1974. Or in some cases, much rarer cases, where the the tenant was earning above the high income threshold. These cases are rare. I'm just going to digress for a minute here and talk a little bit about deregulation, what people generally refer to as luxury deregulation. Most of the luxury deregulation occurs on a vacancy, and the rent is brought above the threshold. For many years, that threshold was $2,000. It eventually went to $2,500, and then to $2,700. And I think it's a little bit above that now because that deregulation threshold is supposed to be brought up at the same rate as the 1-year rent guidelines. So, we have a 1.25% increase this year, which means that deregulation threshold is going to creep up a little bit. Okay. So, deregulation was occurring en masse. Hundreds of thousands of units were coming out, mainly through vacancy deregulation. Another form was high income. For a time, if you made over 200,000, and then I think it was 175. Now it's back to 200,000, and your rent exceeded the threshold. Now again, just over 2,700. then you could be subject to deregulation even while you were in occupancy. Okay, so for those of you here who don't earn over $200,000 a year, you don't have to worry about it. And it has to be $200,000 in 2 consecutive years. So that's a very small group of tenants that are affected by that, a small group of units. So we're mainly concerned with units that have become vacant over time and out of the rent regulation system. So then the owner has taken a J51 tax credit to help fund improvements, roofs, boilers, facades, whatever. The law is now recognized in every court in the state, all the way up and down the line. It's not in dispute that the apartment has to be stabilized, regardless of whether it was luxury decontrolled or regardless of whether the rents are high enough to have pulled it out of stabilization. So you could have a rent of $3,000 or even $4,000, and it could still be stabilized with a new tenant if it's receiving J51. So what about somebody who moves in after the J51 abatement has expired, and they're typically 14 years in length? So you move in the 15th or 16th year and you're paying $3,000 a month in rent. Would you be rent stabilized? And the answer is no. What if the owner recognized your stabilized status, J51, and in each and every lease that they received the J51 benefit said that you will become deregulated or destabilized when the abatement expires? Would you lose your protection then? The answer is yes, but it almost never happens. And the reason is, before 2009, virtually no owners that I know of ever put that notice because they didn't recognize the stabilized status of their tenants. So people who are living in J51 buildings never got the annual notices that are required in order to sunset the protection, and hence they remain stabilized through the rest of their tenancy. If you were in occupancy when J51 was in effect, and your owner got the benefit, and you are stabilized at that point in time, you remain stabilized. There is an argument that if your income goes above the $200,000 after the expiration, that you might be subject to high income deregulation. That is back for the duration of your tenancy. Now let's say you've been in this building for 12 years. There may have been a J51 that ran out 10 years ago, so you had a 2-year overlap. So you want to go back. Probably the easiest thing to do is start from the beginning of your tenancy. So 12 years ago would be what? 2005. So you put in the tax year 2005, and then you'll get basically a grid which shows whether or not it was getting J51, or a message which says, no tax abatement found. It's something to that effect. But you'll see clearly that if there's a tax abatement remaining, it'll show the amount remaining, and it'll show how many years the abatement was for. So if you moved in 2005 and you find that there's a J51 tax abatement and you're paying $3,000 a month, yeah, but that's for the next presentation. So if you find that there was a J51 in 2005 while you were living there, you are rent stabilized. And so then the next issue is, well, if I was rent stabilized, did the owner overcharge me? Okay. So then you want to get your rent history from DHCR, which can be done in a number of ways. You can do it by email at rentinfo@nyshcr.org. You can call the rent info hotline. Everybody here who's rent stabilized should have their rent history. You should at least get it once and see what's going on in your building. The rent info hotline, which can take a little bit of time, but the rent history will be printed and mailed directly to your apartment. Number 718-739-6400. Right, and you can get it. I think it's here, right?
Yeah, it's in this building. Call it again. 718. It's in this
718-739-6400. you can, and number 3 is visit the borough office. I don't usually come up here because I go downtown 25 Beaver Street, but yeah.
I've come here and it's always pretty empty and everybody's polite.
Also on Acris, you can get a lot of building history, like the regulatory agreement.
Right.
That between the city and them. I found it on Acris.
Right.
The deed
And
info,
Acris, you can get the
American
deeds
Trade
and all that. Yeah.
Excuse me.
Yeah.
Can you repeat the phone number again?
The phone number is 718-739-6400. Now, if you come to this building here for your rent history, you want to get a certified copy, because you can use that in any legal
That's what they
proceeding.
give you.
And you want to bring your photo ID and a proof of tenancy, which is a copy of your lease, a rent receipt, or a utility bill.
That's right.
So you need to show that you actually live there. Yes.
Yeah, what if your landlord hasn't filed like the certificate registration?
With the ECR rent registration?
Yeah, but you have,
It'll say no registration found.
what if they haven't done that for the past 3 years, but landlord has sent you the certificate of registration, your lease and everything? I mean,
Well, if they're not actually registering with DHCR, then you have a complaint. You can file a complaint saying that failure to register.
okay, thank you.
Hello?
Yes.
Is there any way that you can find out history from like NYCHA?
Well, if you're in a public housing building, the rent stabilization wouldn't apply.
I know.
So, yeah, I don't know. I'm not a NYCHA person, so I'm not sure. But it wouldn't relate to the J51 issue. Okay, so now we get to the complicated part. You moved in 2005. Landlord had the J51 abatement for the first 2 years of your tenancy. You get your rent history and you see that it says exempt all the way through, okay? But the last legal rent for your apartment before you moved in that's registered, let's say it was 1998. And the 1998 rent says it was $400 a month. So now you're scratching your head and you're wondering, did I get ripped off here? Did I move into a building that the owner treated as unregulated and jacked up the rent and I'm paying a fortune for it? Okay?
Sounds like it.
Okay. So there's been a lot of back and forth between the DHCR and the courts about how to set the rent. Now, I'm going to give you a couple of different scenarios. Let's move our start date forward so it's after the Roberts decision. Let's say that you moved in now in 2012. The Roberts decision happened in 2009. Everybody in the industry talked about Roberts because the real estate industry thought it was a disaster. Oh my God, all of these buildings are now under rent stabilization. We're now exposed to overcharge proceedings. So 3 years later, while you're getting a J51, you get a new tenant and you're still charging an illegal rent. You charge that new tenant $3,000 or whatever when you know that the legal rent, the last legal rent was, say, like we said, $400. Okay. Under that scenario, you could argue that the owner knew or clearly should have known, and that the decision to rent to you at $3,000 a month was pure fraud. Okay?
With malicious intent.
Well, I don't know about malicious intent, but you know, that's only for like
Sounds
murder.
good.
Malice aforethought.
Yeah, okay.
It's fraud. So you have to make a claim, you have to make an argument that there is evidence that the owner knew it was fraud. Now, before 2009, you clearly can't make that claim because the DHCR itself didn't recognize your stabilized status, and the owners didn't. So you can't say that the owner fraudulently was trying to rip you off. But by 2012, 2013, you might be able to make that argument, and we do. That's something that you would have to speak to a lawyer about. We haven't seen success in that argument yet, but remember, we're now just not that far beyond Roberts, and we're just getting into these cases where we could argue, you know, by 2012, that owner really should have known what their obligations were. And so by overcharging you, there's clearly a fraud. And if you prove fraud, there's a whole different formula for setting your rents. You look at the lowest rent on the base date. The base date is 4 years before you file. It's a 4-year statute of limitations. the lowest rent in a comparable apartment in the building. So if Mrs. Jones down in, 4W was paying $220 a month on the base date, that is your new rent. If there was fraud, and you may be able to show treble damages. And treble damages mean going back 2 years. You get straight line damages going back 4 years, but treble damages go back 2 years. Now that's a kind of an optimistic scenario, and fraud, like I said, has not been shown in the J51 context because most of these cases came up at a time when DHCR itself, most of the beginning of the stabilization occurred at a time when DHCR itself didn't recognize stabilized status because of J51. Okay, so let's say there's no fraud, which is the most likely scenario for the vast, vast majority of people who are stabilized by virtue of J51. There was a dispute. Do we go back 4 years and look at whatever it was you paid 4 years ago? Which means that, you might have been paying $2,900 or $2,800 4 years ago, which is not a whole lot below the $3,000 you're paying now. And so even if you prove that you're stabilized, you may have no overcharge if they use the 4-year base date rent charged and paid as the base rent. But a recent decision, late in May, just changed that, and the DHCR's policy had been changing with respect to that. So now what they do is something we generally refer to as bridging the gap. Bridging the gap means looking beyond the 4-year period, which under normal circumstances they're not allowed to do, looking beyond the 4-year period to the last registered rent. So let's say that rent in 1998 was, $400 a month? And then raising it by the rent guidelines amounts for 1-year leases, or 2 years. I'm not sure if DHCR uses 2, they may use 2. So bridging the gap is raising it by those amounts and adding in the MCIs and vacancy allowances and so on that may have occurred to get up to where your rent should be today. So a $400 a month rent in 1998 brought up to 2017 could be $1,500, $1,600, maybe $2,000.
Maybe not.
Maybe not, but it's going to be below the $3,000 situation. So that's the remedy, and this is an appellate division decision. It was very thoroughly reasoned. They looked at all of the different approaches, and they basically said, if there is a J51 situation and the owner was charging whatever rent they wanted to charge under the assumption that it was rent unregulated, they should not be able to take advantage of that, because as they followed the law as it was written and as it was intended, they would have only been able to take those lawful increases, the rent guidelines board increases, and the MCIs and vacancy. So that is the latest iteration of the law. I suspect that'll be upheld if it goes to the Court of Appeals. So you can think in terms of the remedy for J51 at this point in time is bridging the gap, looking beyond the 4 years. Now that may not provide some relief for some people as well, because if you look back to the legal registered rent, it may have been $1,800 in 1998. So if you're paying $3,000 now, may well be you're not even paying what the legal rent would have been had they taken the rent guidelines increase. So that's the math that you have to do to determine whether or not there's a claim. Yeah.
Do you mind sharing the name of that case?
No. In fact, I'll do more. Yeah, here you go. One extra. I just have one other one. I'm sorry. This is Taylor versus 72 Realty Associates. And there's no official site. When I printed this out because it was so new, but I'm sure there is one now. You can probably Google it. Taylor, Taylor, the 72A Realty Associates. ASSOC period LP. Yeah.
Would something similar apply in the 421A context, where we basically had a landlord that never registered the building as 421A? And I'm not talking about like a luxury.
Right.
In the outer boroughs, there are a lot of 421A buildings that are like 3-4 families.
Right.
They're they're just, and they were like we've seen a couple of cases recently where landlords just never ever registered.
Right. The thing about 421As is there should be there is an application for 421A, and you have to put down your rent roll. So there is, HDD will have that, and there has to be a proposed rent roll because that is a condition of getting 421A. You have to say your rent. I mean, I've seen them. If they didn't do that, I don't know how they get their 421A.
When you apply for 421A, you provide HPD.
Yeah, it's part of the. It should be part of the whole history. Yeah,
Can you get that?
I would think
Possibly.
so. Yeah, I would think so. Yeah, I haven't had to do it. I've gotten it in discovery. I don't have that.
I've done that, and if they tell you no, then challenge them again. Because that's what I did.
Yes, sir. Yes. I'm sorry, I got a little noise coming from here, so just shout at me. Don't worry about it. Speak up. Go ahead.
How would you calculate the rent stabilized building where?
I still can't hear. I'm sorry.
How would you calculate the rent stabilized building where maybe the owner, you are being charged an X amount of rent for a period of 16 years? The building got turned over,
Right.
maybe sold.
Right.
You owner, maybe to make the paperwork go through in terms of the sale of the building, which has already been identified as a rent stabilized building.
Right.
They looked at the record,
Right.
adjusted the rent, reduced it by 1/3. Now, subsequently deciding now that because of the last lease which the tenant provided to them, which showed what they had been paying all those years, even though those rents over the years may have been incorrect,
Right.
decides to now go back again,
Right.
a year after taking over the building, to the wrong rent. Which calculation applies here?
Well, is the regular rental building?
This is a rent stabilized building, yes.
Okay.
Of 36
How many units?
36. No, I'm sorry. Yeah, 36 buildings.
Okay. And when was it built? Do you know? Is it an old building?
It's a whole building.
Okay. So, have you gotten the rent history from DHCR?
Yes. The rent history, the one thing also I want to ask you is, how does it work when they're registering? If for the past 16 years, rent history was never reported, but then again,
What does the rent history say? Does it say exempt? Does it say what the rents are?
the rent history showed that it was registered retroactively after the new owner took over the building.
That's the problem. Yeah.
Now, even with the retroactive registration, which showed months after the new owner took over the building,
Right.
they were still able to show that for maybe a period of about 10 years, the particular apartment that we're speaking of was vacant, which, according to some DHCR regs, maybe justifies the rent reduction. Now, they went back to the increase which the new owner applied was basically based on what the last occupant paid, taking into consideration the vacant years.
Okay, look, the whole question here, because we could get lost in the details, the question here is whether or not this is a situation involving fraud.
Yes.
Well, you're assuming it, but you have to prove a lot to prove
Exactly.
fraud. And hold on, there's a 4-year statute of limitation. The DHCR will only look back to 4 years prior to filing the complaint. Whatever was charged and paid on that date is the legal rent, unless you can show that there was a fraudulent scheme to pull the unit out of stabilization. Okay? There's a lot of case law and it's very complicated. But that's what you have to do. You have to show fraud. And with that, you really need to speak to a private attorney and talk about all the details, including the rent history, including whatever it is the owner filed, trying to whitewash the old rent history. And that's what they try to do. I've seen it many, many times. They'll come in years later and they'll just wipe out the old rent history and file it, and DHCR won't look behind the curtain. And it's very upsetting, but it happens.
Can I ask just one footnote? Sorry, real quickly. Sorry, everyone. What it showed was within a 3-month period of pulling the first rent history, for example, in January of 2017.
Yeah.
Then going back 3 months later, after the landlord was told, listen, this is the right amount of rent to charge, and that's exactly what I'm paying now after you took over the building.
Right.
Immediately after that conversation took place, they went back and padded the books.
Right.
They started
They whitewashed the rent
yes.
history a second
For
time.
those vacant years, they now went in there and started adding the increase.
It's part of the argument that you would make about fraud. Okay, so you would make the argument, and whether you're successful or not, I don't know, because DHCR is like, trying to blast through a brick wall when it comes to looking behind the records that the owners make.
That is the dilemma. But whether those 4 years is the only thing they'll look at, or they'll look at even if all this rent over the years.
The one word is fraud. If you can establish a colorable claim of fraud, okay, then they are supposed to, they're obligated to look back.
Thank you.
Okay, I have a situation here. My nephew, he's been living in his apartment for 6 years. 2 years, 2 years. Just about 3 months ago, new management take over.
Right.
And they're sending him a notice letter of increase. But the lease is not yet expired. And then now, so he was paying 13 something. They're now telling me it's 17 something. Wow. How much?
13.
Well, it sounds like he had a preferential rent, and the question is, did he preserve the preferential rent? No, I understand, but you understand what a preferential rent is?
No.
Legal rent.
Yeah, I do.
Legal rent could be $2,000. The landlord could charge you $1,500. If the landlord has an agreement with you saying that that's what you have to pay for, that you're entitled to the preferential rent for the duration of your tenancy or for a fixed period, then the landlord has to honor that. If the landlord doesn't have an agreement and just says, I'll charge you a lower rent for this lease, then the landlord can bring it right up to the legal rent the next time
But I
around.
think the basic question is, if you have a lease that
not
states
yet
that's for
That's not
that's
yet
not
expired. I
expired,
know. I understand.
how do they
That's
do
a
that?
separate part of the question. I want to answer the jump first. If you have a lease that's in effect, the landlord cannot increase the rent while the lease is in effect.
But I do understand
Even though
your
it's a new
whole.
landlord, take a look at that.
That's right. Doesn't matter if it's rent stabilized.
But I do understand
folks,
your argument.
It's 1:30. I would ask you to fill out the evaluation. I appreciate all your questions and your time. I don't know where they are. They're up front here. You can always look at the
Inspection is starting 20 minutes.